And I'll kick it back over to Wen.
Yeah, thank you. So before we get into the new guidances that's come out of from the USPTO, I just wanted to hit on a couple of things that stems from the last conversation. And one of them is so in terms of writing the spec to support the claims and everything, what are sort of safety net sections or language that you've started to integrate into your AI applications in view of, maybe the new guidance and everything, and such as, practical application, improvements, anything else and how does it vary depending on your different technologies, if it does vary? I thought maybe we start with Brian.
Sure.
Yeah.
Yeah, this is certainly cutting edge. We're actually reviewing a lot of this internally now, along with getting opinions from outside counsel in view of the PTO's new AI co-inventor guidance.
Mm-hmm.
As far as what goes into the specification, it really is kind of depending on what we're doing. I, in my practice, really try to harp on what are the improvements and put it to me in plain language that I think an examiner can understand, as well as a jury potentially. But just to me, that's probably one of the single most important things that I want to see in every one of my applications, that I can point to something, not necessarily, I've had success in terms of the drafting, even if it's not in the claim and the examiner wants it in the claim. Sometimes it's enough to be able to point to the spec. I've also had favorable appeal decisions by, again, citing to the spec, it's there. And if it's there, it could, in some fashion, perhaps awkwardly be brought into the claims and, some other continuation down the road. But just having that bedrock in the application, in the spec, is just crucial.
And do you use any glossary? I've started to do this, integrate, this is what this means. It's specifically a section says, when I said this, I mean this.
If it's not relatable, if it's not readily understood, then it needs to be at least not necessarily a hard-coded glossary. That it depends. Sometimes it could be this is this. I still cling on to a lot of permissive language that it may be this.
Yeah.
Not necessarily.
But the examiners get on you for that.
And I mean, we can always, hone in on that as we need to.
And how much of a maybe foreign filing strategy do you integrate into that? In that, there are certain requirements in EP and what you need to have in order to meet those. If you use your U.S. application to go abroad, from what my clients do you have to think about that as well?
I have to think about it.
Yeah.
That is coming from a U.S.-centric approach myself. That's constantly an area of evolving knowledge, and I'm fortunate that I have European colleagues within 3M that I can consult on these things. I think the more I learn, the more crucial it is to at least be aware that taking a U.S.-centric approach is not always going to pan out the way you want it to at least have that knowledge about how do you want this drafted, because that will flavor how it goes from there on out.
Definitely. Yeah. What about you, Rob?
Well, first off, I'm definitely going to adopt the phrase area of evolving knowledge to refer to stuff I don't know. So that's a great contribution. But two things I do, I focus on with the spec. And I think one that is probably AI, to some extent is AI specific because it's so cutting edge, is I'm actually very sensitive to accidentally invoking means plus function in the claims. Because I would say a decent rule of thumb is if either you as the patent attorney came up with a term, or your inventor came up with a term. If it's not in the technical literature there somewhere, there's at least a risk that will be interpreted as means plus function, step plus function language. And
function is a genus now, is very susceptible to being determined to be a genus.
And that's not to say don't be your own lexicographer. It's more along the lines of because this could invoke means plus function, let's make sure we build enough information into the spec so that if it is challenged on that basis, we can survive the challenge.
It is very easy to invoke means plus function in AI drafting. I think it's unavoidable in some ways. Yeah.
And the other piece of it is more minor, but sometimes when I was still practicing, I did tend to over-explain things that were known in the art. I mean, explaining how a neural network works, explaining how a decision tree works. Not so much because I was worried about those things specifically, but I think if you get in the habit of relying too much, well, I'll put it this way. Sure, you can rely on what's well known to fill gaps in enablement.
Yeah.
But if you're going to rely on those, then if those features are, if you're relying on something well known to fill gaps in enablement, you also may be surrendering ground that additional claim features are well known and conventional, et cetera.
Yeah.
And so I at least try to avoid over reliance on what's well known in the art to plug gaps in the spec, just so that at the very least I have a chance to fight back against those.
And in a field like AI, I mean, what's well known evolves very rapidly, so it could change. Yes, Dina, what about you? Anything that you like to always include in your spec?
So what I started doing, especially with AI apps, I have several figures that describe how AI works, and they're different for different types of AI models. So I would pick one or two to include in the application, but then I would also tailor them to the particular invention. Something else I started doing, I'm always thinking what type of AI is in the application. Is it the improvement to the AI itself, or is AI being used as a service, or can I do a combination of a couple of AI models? And based on which way the patent application goes, I try to frame that as being the improvement.
Thank you. Mr. Commissioner, is means plus function the kiss of death? Is it something that it's unavoidable, but our examiners just, is like a reflex?
So I won't say it's the kiss of death, right? To me, it should be a choice, right? And it should be a known choice, and not something that you write your claims and then you later find out, okay, this is being interpreted as means plus function. So I hope that somehow the record is clear during prosecution on whether claims are treated as means plus function or not, so that the applicant can choose to change course if they think that that's what they want to do. I know that was something I was pushing at PTO. I don't know how prevalent it is that examiners are actually clarifying the record, but it should be very easy for them to say, yes, this is or isn't means plus function, and that way you just put the applicant on notice and let the applicant decide.
That was something that I wanted to ask too, because from what I hear is a lot of times examiners will say that they're raising this because they need to make a clear record, and it's not quite as much as, my speed told me to reject everything under 101 and then place the burden on you, but it feels a little bit like that. Is that speed dependent, or is that like office policy, or is it examiner dependent?
So I'll talk when I was commissioner for patents. My goal was a clear record, and that's very different from saying you're rejecting. Right, so it shouldn't be speed dependent on clarifying a record. It was office policy that you're going to clarify the record. And I honestly spent years and years with different iterations about means plus function, about just how, what is the best course to do this. I think PTO came out with a notice, would the applicant, state, if they thought it was means plus function and no applicant wanted to do that, and I get that. So we put it on the examiners to say, these are literally form paragraphs that you can just click and say, this claim is treated or isn't treated like means plus function. And that way the applicant is on notice and the public's on notice, and the applicant can always choose to take a different course. That's the goal. I think people are creatures of habit. It was hard to get a lot of uptake, quite frankly, but as time marches on, hopefully examiners are doing it more and more. I just want to add a word on the spec. I'm not on the front end of drafting, as I mentioned right now, but I'm on the back end of answering a lot of questions. And the problem that I see routinely is that somebody wants to you're having a problem getting a claim allowed for whatever reason, 112 or even art sometimes, and you want to rely on something that's not in your spec.
Yeah.
So I think it was said before that the spec was most important, and that you'll figure out the claims, and I don't know, I won't say more important or not, but what I will say is it is critical that the spec should have everything that you need and you might need, and to me that's of critical importance. And I do agree very much that the claims will evolve during prosecution, possibly with continuations, but you need the foundation of that specification to be able to go back to what you need in that spec when you need it.
Yeah. Mike, anything that you always include in your spec now?
Yeah, I do two things, and it's really drawing on two things that Dina and Brian said. So first, Dina mentioned that she includes AI-specific figures. I do that as well, and I break it down into a section about training and a section about architecture, and separate that from a section about how the application is applied. And if you do those things, if you treat each of those individually, how is this specific invention trained, or this specific model trained? What is are the architectural elements of this? And I include all of that, and some of it is boilerplate, but a diffusion model might seem, I do them all the time for image generation, but the examiner's not going to know what diffusion means or how that works or how they're trained, and so you got to put all that in there. The second thing I wanted to talk about is the question of the talking about the improvement, and one thing that I think is a little bit unfortunate is the word improvement has some ambiguity in it. It can mean either the technical structural difference between what you're doing and how other people are doing it, or it can mean the resulting advantage of doing it that way.
Yes.
And for me, it's very important that both of those things are described separately. And so we always include a paragraph that says, here is the advantage, like we're doing, and it's usually in my field, it's something to do with either accuracy or efficiency. And so I want to hear something related to like one of those two words. Ours does this thing more accurately or more efficiently. And then I want to hear the structural difference that creates that result. And so if I just say improvement, I think sometimes people are thinking one thing, or sometimes people are thinking other thing. And for me, it's absolutely essential that both things are thought about. And there's a specific, and I make the person who's drafting say, this is the paragraph where that's my advantageous paragraph, and it has to have both of those things.
And Mike, you said you have a architecture section, you have an applied section, a use section. Do you have maybe like the loss function section or something, anything like that?
Yes, in the training, yeah. I think it's useful to describe your loss functions, and often that'll have multiple parts to it, and it'll be quite complex. And sometimes there's novelty in the loss. That's absolutely. And what does loss function mean? You got to have both have the basics and the particulars about what kind of loss function you're using.
Yeah. No, so these applications can end up just being very, very long until we all get accustomed to it, and then we have so much language that we're accustomed to using. Hopefully, that'll help
they
us
get
speed
long,
up.
but we do have a library of boilerplate to use. If we're gonna, again, like if it's an RNN, we've got boilerplate we're going to have about an RNN, but we include that because I found in prosecution that it sometimes helps to, to sometimes actually include in my claim some details that are actually kind of generic to the operation of neural networks, but sometimes putting it in there helps frame the application as a, as something different than just how a human would do it.
Okay, thank you. Yes, Suman, what about you?
Right, so specifically for machine learning, it's similar in some respects to other computer science applications, but I think it's so much more complicated that in the first few paragraphs, I'll try to lay it out, from the perspective of sort of how a high-level, intelligent high school student would be able to understand. And in doing that, my goal is because a lot of these examiners, like we touched on earlier, they don't know what this is. Like they're in, a totally different art unit, they get machine learning, and they need to figure out what this is. So before I dive into the technical details, I'll try to give them a little bit of a story of, hey, here's the problem, here's what we're doing, and this is how we're solving, what happened before. And I'll throw the independent claim in there somewhere too, so that way they can make that clear linkage that, okay, here's the problem, here's the solution, oh, and their independent claim is right there too. So hopefully that'll get from the outset address some of the 101 issues. And I found that to be pretty successful in many art units. Not all of them, but mostly it's been helpful for overcoming that. And then in terms of, the flow of the application afterwards, then it gets far more technical the deeper in you go. And, with those like different architectural, diagrams we were discussing, weave those in, but I'll typically put those in closer to the end. I just want to make the first few pages of the application really clear to the examiner, including the first figure, to tell that story from a high level. Here's what our invention is, here's how we solve it, and here's what the problem was before.
I started including, this is what's conventional, and then talk about differences or improvements. Yeah, and just in certain applications when it's, when it's useful. Have you had any problems with talking about what's conventional?
Well, I try to avoid conventional just because it's such a trigger word for examiners to then say that's prior art.
Yeah.
I may say like existing solutions or, suffer from some issues related to this. Then maybe say, inventors identified those, problems, and then say an enhanced sort of examples herein or something to kind of distinguish between the two. I haven't run into problems yet with it, but I understand there is a risk that examiners will focus in on that and say, well, that's clearly prior art. I would say like prior art sections are usually short for a reason. We don't want to stop ourselves from getting anything during prosecution, and sometimes the examiners will misinterpret what we're writing. So I try to be a little guarded with those details, but yeah, sometimes you do have to put it in order to get over that 101 and to avoid delaying prosecution, right?
Good point. Thank you. What about you, Dan? Anything that you always like to include?
Well, it's hard to go seventh, isn't it? I do agree with a lot of what was said. I guess the two things maybe to emphasize. One is your question is sort of additive. What would you add? I think a big piece of drafting, and I think Brian hit on this, is removing stuff. Like, why is this in there? Like inventor jargon, like unnecessary detail that are going to be distracting. So making sure you find some time to do that. So that's number one. Number two is to pick up on what Mike was talking about in improvements. I think what I often see is, oh, here's my 2 paragraphs on 101. Like, I'll have a junior person who's working with me. They'll show me the application. I'll look at the claim, and I'll say, all right, well, if I reject it under 101 like this, what are you going to point to in the spec? Like, where are the 2 paragraphs? And so they'll show me the 2 paragraphs. But then what happens next is, okay, but what if now I have to amend because of prior art, and I bring dependent claim 4 into claim 1? And now there's a 101 rejection. Now what are you going to do? And the problem sometimes is that you don't tell the improvement story at the level of additional features. If you only tell the improvement story about the original claim 1, and it's like broad claim 1.
Okay, this is graduate level stuff now.
I have to go 7th. So like the guidance, and all people love using the word nexus. You need a nexus between your improvement story and what's distinguishing the prior art. And so therefore, if it's going to be claim 5 that you really think has like the thing, and your claim 1 is a bit of a reach, it's a little broader, but you know that more likely than not, claim 5 is going to end up in the independent claim. It's probably a good idea to think about in a story that you're going to tell for why that stuff helps you in 101 as well.
Thank you. I'm going to stop here for questions.
I have a question. It's something now that Dan mentioned and Mike has mentioned here about what how you said, the story. And the paragraph that you say you were putting in seemed to me to be sort of what I would call like an end-fish paragraph, so this is better than anything that's come before. One of the things I think that really got us into trouble with software, generally speaking, was KSR and the draconian ways that a lot of attorneys interpreted it and say, oh, you can't say anything about the prior art because it can only be used against you. And then you read these things in all patent applications for a while, and you get to the end and it's like, what the hell is new here? What has actually been invented?
Yeah.
And it's listening to all of you, and you all comment on this if you want, and particularly from the areas that you work in within the AI ML space. But how far away from that what I call overreaction from KSR are we with respect to AI? I think you have to actually explain what it is, what is new, what is different, in ways that 15 years ago, attorneys would say, "Oh my God, what are you doing?" Right? Is that?
So I think you hit the nail on the head, right? Like if you read patents and patent applications from certain time periods, right, they're just going to feel different, right? After State Street, they look different. After Bilski, they look different. KSR. It depends on what you're trying to do, but I very strongly veer toward you need a story to have success. You need a story to have success in the U.S. for one-on-one reasons, but also more fundamentally in any area that's busy. People are working in it. There's a lot of innovation. It's a filled landscape. You're going to have obviousness challenges too. Like initially in like 2015, 2014, when some of this started to heat up, you'd get invention disclosures that are like, oh, I just downloaded like this tool from whatever website and I have my own data, so I applied it and I got an answer. And maybe you could get a patent on that back then, but now that's no way. You have to explain why it is that what you've done goes far beyond that. And you need it for foreign prosecution as well. In Europe, that's never been something that could work without a story. So I think you need much more of a story if you're going to succeed.
And
Can
you need, and you need the story for litigation as well. If the patent is ever litigated, by putting a story in the patent application during prosecution, you're setting yourself up for the success in the litigation.
I just want to comment on sort of a strategy, because when we tell the story, it's also more or less fiction. It doesn't actually have to be like reflect reality. You don't want to stray too far from reality, but
Or practice fraud on the patent office.
yeah, you don't want it to be fraud. You don't want it to be fraud, but it is fiction. And in the following way, it's because
Will's not here. The director of OD will be here momentarily, but you are safe for now.
Yeah, can we turn off all recording devices? When you talk about the prior art and what's conventional or pre-existing or anything like that, I think it actually is better to make some admission about prior art. But you get to choose how you characterize the state of the art. And you don't have to characterize the state of the art as it was 6 hours ago, or right the minute before your invention. You want to push this prior art back to something kind of reasonable. So I work in image generation a lot. I admit the existence of image generation models, you know, but I'm going to keep it pretty broad and
No, but I think that's the way you have to go, right? I mean, I never understood, like, me not saying something, and I understand the baggage and prior art and anything, but if I act like this is the first time that anybody's ever seen a chair, and I define it from the legs up, and it's like, come on, who's fooling who? Nobody. And what it does is it misses an opportunity for me to actually accentuate the positive. Because if I didn't tell you what's basically out there and why ours is different, I can't possibly focus on the positive. And that, not that there's supposed to be a point of novelty, but really that's what we're trying to accentuate, right? And talk about that to the exclusion of all the other stuff that really doesn't help as much.
But when I'm drafting, I limit that to one very specific place in the application, so that I am not throughout the application admitting prior art and risking admitting prior art or doing anything like that, because you gotta set the stage, you gotta tell the story, but you don't want to draft your application so that, like, you're talking about the prior art as prior art, or admitting that something is conventional or pre-existing, like, throughout your draft. It just creates too many places where you could get yourself into trouble. And the focus is on your invention. It's why is this unique? Why is this exciting? Why is this revolutionary, right? You don't have to focus on the negative aspects of prior art. No. This is special sauce. Yeah, so I absolutely do it, and I do it in one specific place where I'm choosing how to tell the story. I choose what the prior art is, I choose what's conventional and what's existing, and I contrast that with what I'm doing, and that's a conscious choice about what the state of the art is.
So now, Dina, I have in my head that you do stuff in the medical bio space. Is that correct?
I started doing it. So
Okay.
I'm a software attorney by trade, but
Right.
because of AI, I started doing a lot more
Right,
of the
so-
biotech applications.
Does any of this change when you're like looking at like broadly speaking in medical or biopharma context related to AI? Is there a different story you need to tell, or is there different techniques as opposed to something that might be more really like just like AI for AI's sake, for lack of a better way to say it?
I mean, the story is the same, but what I found out very quickly is that you really need two patent attorneys to work on these types of applications. So someone who is an expert in the life sciences and biopharma space, and then someone who is an expert in AI space. And very often on the call with inventors, you actually need to pull in coders who are not inventors, who can explain to the scientists how machine learning works. In order to get something substantial that you can put into the application. And then as an attorney, it's your job to gel the two together and figure out where the novelty is.
Can I actually add to that? So I also do a lot of work in biopharma, life sciences, and you almost need a lobotomy. Like if you look at like ECT, like computer, electrical, and like life sciences applications, they look nothing alike, right? The structure of examples. But what it's also interesting, and I'm sure you might object to this characterization, but what I've seen sometimes is, so the 112 treatment is very different. And because it goes to art units where life sciences examiners are used to, the unpredictable arts, and they apply that standard, if AI technology falls into there, they tend to sometimes take that 112 interpretation to AI. So one art unit's 112 for AI technology is not another art unit's 112. So I've had situations where we would think we have fairly conventional, it's in the textbook kind of, model, and the examiner would say, well, you haven't enabled it, this is completely unpredictable, like how do it's the kind of thing we talked about on this panel about examiners not having a ton of experience with it, so then they fall back on examination principles that are prevalent in that art unit, so it makes sense. But it's a challenge. And the second thing you have to care about is there's other kinds of 101 that show up, right? So if we are in the computer units, we're thinking abstract ideas. But if you're moving into molecular diagnostics, companion diagnostics space, now you have to worry about natural laws and correlations, and there's sort of a whole different set of, I like how you say it like a zip code, 101 issues that come out. So you have to plan for those as well.
We got a question. Yeah, yes.
I don't need a microphone. I don't think I do anyway. So I guess my question is, I'm going to ask you guys to predict the future here, particularly Dina and the commissioner. I'm so sorry. So we've read the guidance that the USPTO has set forth in terms of leveraging, or at least identifying inventors as it relates to AI. My own opinion, for whatever it's worth, I think this is going to be particularly prevalent in the life sciences and the pharmaceuticals area, where the use of AI has long been known for the generation of inventions. So, Dina, question for you is, are you starting to gather more information and presenting more information regarding the inventors, the human inventors' contributions towards that development, and then towards the commissioner, in view of the guidance, do you see a situation where examiners are going to start trying to demand that type of information to confirm inventorship? Or is the presumption going to remain, hey, you listed it, it's true?
Yeah. I mean, I think based on the case law, right? So, Thaler versus the Patent Office is a prime example. You need to frame it as an AI being used as a tool, right? Because AI can be an inventor, and the purpose right now is to frame it as, well, I've been using AI to do this, rather than say AI created this output and now I'm trying to patent the output that cannot be.
It just seems like the guidance, it seems like the guidance has created an evidentiary burden on behalf of the applicant, as if it's ever raised, and the examiner could raise it at any point, it seems like, and there's no, probable cause for the examiner to raise the question. Now you have to refute that and say, so what do you tell your clients? Should you be asking them to keep a diary of their AI use,
It's a very difficult question, because particularly in the biospace, where you have the scientists, they're saying, well, we're going to use an AI model, right? But then they hire a contractor who is a source coder to code that model, right? So there is this split between what is being invented and how AI model is being used, right? So sometimes it's very hard to gel the two together. But I think with the current guidance and AI is being a tool, and we make it easier, where you say, well, I have this AI, I've trained it, so maybe my invention is somewhere around training, or maybe combining different models together. and then frame it in a bio context.
Interesting. Rob?
Well, excuse me, it's something I wanted to add to this. I have started at least asking the question of the extent to which AI was used in developing an invention. And the reason for that is that I'm trying to look several years into the future and look what the state of inequitable conduct might be.
Yeah.
And I'm also looking at the present, and I'm seeing trends with respect to AI governance, AI policies, internal documentation of who was authorized to use which AI tools and for what purposes. And I'm looking to the future, and I'm seeing an inequitable conduct claim where there's plenty of documentation that this inventor had access to the generative AI tool, and there's no contemporaneous documentation of the extent to which that AI tool.
Yeah.
played
Contemporaneous
exception.
documentation, I think that is, yeah. And I feel like the AI guidance significantly enhances the burden on inventors and applicants in terms of record keeping in order to meet maybe future regulation. But Mr. Commissioner, is the USPTO just going to take our word for it if we said, no, we didn't use AI to invent this?
So Gene, these are two questions. I think you can do a whole nother day or two on addressing these questions. So there's a lot to be said here. My pause is where to start. My crystal ball, like my thoughts, Drew Hirschfeld's thoughts, are that the USPTO is going to continue to assume that inventorship on the applications is correct. I don't see that PTO is going to want to change that presumption. PTO does not want examiners to be diving into these issues if they can avoid them. They can't take depositions, they can't, get other testimony, et cetera. So I think that my view is PTO is going to stay very, very far away from changing the presumption that the inventorship is correct. That being said, I'm glad to hear that you're asking questions and others are asking questions so Dean and I were talking about this at the break, about the amount of litigation that may ensue about inventorship related to AI. And I do now, as Gene mentioned in the opening, I do expert witness work. I've had a number of cases on inventorship already, none related to AI, but there's already questions about inventorship. Attorneys have a responsibility to investigate inventorship, and so you have to look into these issues. And if I were, in your shoes, I'd have records of what took place. You don't need to put that in the application, but you have to have your records, in my view, because down the road, you don't know if this is going to be an issue that's raised. It also, the guidance to me, or the presumption to me, raises the issue about what you say in your application papers. Because if you are saying something that that overrides the examiner's presumption and provides evidence that maybe examination or maybe inventorship is not correct, that examiner is going to have to look into that. So be really careful about statements you're making in your IDSs, in your specifications, et cetera, that may say, hey, examiner, this presumption is not correct.
My favorite example of that is you list a single inventor, but in your story you keep talking about how the inventors recognized.
So this is something we probably should ask Will when he gets here during the last segment as well, because one of the things that comes to my mind is just the reality of prosecution, right? So I can't imagine the office is ever going to tell examiners, try and figure this out. No, it has to operate on a truth system, right? Like everything else that we tell examiners, they're supposed to take it at face value up until something comes up and a red flag is waved in their face that they can't ignore, right? Having said that, on our level, there can be, because inequitable conduct, a lot of things that look like inequitable conduct are not inequitable conduct, but you really probably don't want to argue that, oh, no, this is not inequitable conduct, this is just malpractice, And one of the things that jumps to mind, particularly with the AI, is how, like if I draft the application and I file the application and then I move on to another firm or retire or die or whatever, and then one of you picks up the application 3, 4, 5 years later when the examiner's doing, and you start canceling claims and there's no kind of record keeping, how are you going to have any faith that you haven't canceled the only claims that the human was attached to? And we all know what that's going to look like when you're looking over somebody's shoulder and you're reading the file, and there's no pressure, and there's 100% knowledge of what actually happened now. There will be an expert somewhere that will say, oh, that's clearly inequitable conduct. Then there'll be an expert that says it's not inequitable conduct, right? But we have right now no idea, no way to know. And we also don't know, and this is why I want to ask Drew this, or Will this question, is how is OED going to look at that? Are they going to expect us to have more obligation to keep records?
Yeah.
And I think the answer probably is yes. And if it's not yes, it should be yes. At least it should be a best practice, I think.
Yeah.
You know, like Drew said, it doesn't have to go into the application.
It's a reasonable investigation.
Reasonable investigation and a notation for the file. It's like, hey, if you get rid of these claims, you have to have at least these claims in this application, you know, or something.
Yeah, Brian, as in-house counsel, we're interested in your perspective. Does that really increase your operation costs to be able to keep these kinds of contemporaneous records?
It could.
Yeah.
It certainly could. And it kind of raises a question I've raised internally about how do we want to make that assessment? Do we want to take the inventors at their word and have them kind of certify to us about where those lines are, or are we the ones certify? If you think about like, you know, petition to make special, you know, are you, or small entity, are we investigating that information, or are we taking at face value what our client tells us? So I think each organization is going to have to figure out where that line is.
And as the patent attorney, I think it's our job now to always ask during the disclosure process how much AI was used in the inventing process.
I mean, Gene's point is also not a new one. Even if you have an application with 5 inventors, and somebody retires and you pick up a case and then you cancel some claims, it's the same question. Well, maybe there was inventor number 5 was only there because of claim number 30 and you removed it. You have to have a system for for dealing with that, and it varies across clients, and I can't say that every strategy is without some risk.
See, and I agree. This is not necessarily new, but with one exception is in those other cases, the district courts, they'll let you fix inventorship, and you know, as long as there wasn't any nefarious activity going on, right? And even sometimes if there is certain levels of nefarious activity, like you always name the president and CEO on every patent that is filed, right? Like they still excuse stuff like that, but this is going to be one where all the rights might get thrown away,
right?
You know, in a way that I don't think we've seen before. And I don't know that the way that the law is currently developing, that there will be a district court judge who could say, oh, well, no, the patent office let him change the inventorship. I'm okay with that, you know, or it could be a real mess.
Well, you can always disclaim a claim if you have an issue with the dependent claims. Right. If you have an issue with an independent claim, there may not be a way around it.
Right.
Yeah.
And I think the stakes are a little higher. I'm not aware, if anybody is, please correct me, the traditional issue was inventors that should have been on there not being on there. I'm not aware of any patent that's ever been invalidated because CEO was on there. Now you're talking about AI is the only one on there, and for the first time, you removing somebody could have a much more profound consequence.
Right. Right. Well, a lot of Apple's portfolio wouldn't be worth anything if it could be invalidated simply because the president and CEO is on all of them. That's tongue in cheek. It's a joke. But Steve Jobs, when he was alive, seemed to be very inventive. Now, Gary has a question.
Oh, yes, please.
Different Gary.
Going back to what Rob said and the commissioner and Gene, one of the things that I'm finding is AI may not have been included in the original disclosure, but then as a patent attorney drafting, we ask a whole bunch of questions. I'm finding out that they look up those questions using AI, and sometimes they make it into a dependent claim, that if we have to rely on a dependent claim for novelty, is it novel? Because it was AI that came up with the novel entity.
I mean, you could try to argue against it by saying there's sort of case law that says if somebody's apprising you of information that's already known, that is not a contribution to inventorship. And if AI was trained and whatever output it gave you was already known, the counterpoint to that is maybe in combination with other things in your application it is new. So it's a tough one, I think.
I think there's some language in the guidance about recognition and appreciation being vital to the question of inventorship. I think that's something we could always argue, that if we all concede that AI is incapable of conceiving, it's not capable of recognition and appreciation. So it's not an inventor on any of these claims, arguably. Yes.
You know, tongue in cheek, we talked about during the antitrust panel yesterday. It was like, if you take AI out and insert a guy named Bob. So I think maybe we just need to always have Bob be a co-inventor. You know, and I wonder, you know, and I say that tongue in cheek in some respects, but I mean, there's got to be some people that are going to do strange things like that. You know, like Max Headroom is the co-inventor, right? Not an AI. He's sort of like a quasi-real person.
So the guidance is unusual in the sense that I think it provides for a obligation that to a certain extent we already had, as everyone's talked about, but to a certain extent we didn't either. And for many years I've done patent interferences, and inventorship would often be an issue in these cases in a couple different ways. In one way, it would be if you included an inventor on the case, that person didn't join until late, well, that's your date of invention. So you'd try to get rid of that person somehow or explain why they weren't an inventor of the main concept. On the other hand, sometimes you would see it where the person was left off to prevent joint ownership, or put on to and provide joint ownership to give a free license. And Drew, I don't know if any of the cases that you're working on that you can talk about involve this, but in my experience, it's so difficult to figure out what inventorship is that you really have to almost show some nefarious purpose for it before you have before a judge is going to pay attention to it and say, yeah, that's a problem. Otherwise, the cases that go back to the 1920s say this is one of the most difficult concepts there is. And so, if you didn't get it right, well, we can fix it. And I also think that this idea that computers or the AI is an inventor is just not true for exactly the reason you said. There are numerous cases in the interference context where someone made the invention but didn't recognize it, so-called nunc-pro-tunc inventions, and they don't get credit for those. Well, the same thing is true of computers. Someone has to look at it, you, as a part of writing the application, say, oh, there's the invention, that's you or the inventor or whatever. And so that's where the inventorship occurs. It's not, the computer's not doing it in a vacuum. And the last thing I would say is just remind everyone that inventorship is a mixed question of fact and law. Inventors cannot decide it on their own. They give you the facts, and then you advise them as to whether they're an inventor or not.
I want to just raise another inventorship question that comes up more often than the AI inventor. If you're drafting a patent about AI, it's usually not as much as if it might be like the pharma situation. But one thing that comes up a lot is my inventors want to publish.
Yeah.
And when they publish a paper that's related to the invention, the list of authors on the paper are not always the same as the list of inventors. That's an issue that's come up several times for me, and that's when I want to get something address that question directly and have something on the record that we are very clear about why or why not that author is not an inventor on the application. And what it turns out to be, the most common situation for me is some of the companies I work use interns, and those interns are students who have advisors at the school, and they list their advisor as a matter of course on any paper they publish. but they were doing this as an intern, you know, at a company. But it turns out this happens surprisingly often. And so I think inventorship is an issue, but for me, it's the inventorship comes up much more often in the context of these are scholars, and the rules for scholars and the expectations for scholars are a little bit different than the rules for inventors. And so then we have to be, you know, then you have to have something on the record, I think.
I think the MPEP addresses that. I think there's a small section in the MPEP that specifically says that people named on a research paper are not necessarily inventors for the reason that they recognize that you know, the standards for who's on a paper could be anything. They're not inventorship standards.
It comes up in the 130 area, the affidavit area too, because you know if there's not an identity between the publication and the application, the examiners may be able to use the publication as prima facie to reject you, and then they forces you to file the 130 affidavit. So it is a ball of wax that you probably don't want to have to deal with if you don't have to, and certainly if you're going to be in that situation where there's going to be a different number of people on the publication, you want to make your life and everybody's life easier, file before that publishes, for sure. And if you don't, then you're going to have just other nightmares, you know, on top of the inventorship nightmare as well.
Or business opportunities. If it wasn't your fault that you
Right,
didn't
right.
file it before it published.
Yeah. Okay.
Is there another question?
So I've thought about this a little bit, and I brought it up at another event, IPWatchdog event before, but you know, when it comes to what's a significant contribution, it's so subjective, just like obviousness or what's abstract. And I wonder if there's another way around this, and what it would be a minor revolution in US patent law, but what do you think if we modeled ourselves more after Europe or China, where it's really the applicant, the assignee, that matters more? Because as we integrate AI into this stuff, it's going to be hard to figure out what's significant. Just like Gene said yesterday, I mean, the quiet part out loud is that patent attorneys really do a lot of inventing as it is anyway. And that stuff works its way into the claim. And if you want to be hyper-technical, you know, that patent could be invalid too, just because a patent attorney's, you know, conception made it in. So, I mean, I know this is really revolutionary, but what do y'all think of that? Should we evaluate how much emphasis we really put on inventorship in the first place?
Yeah, should there be inventors, or we just have an applicant system?
Yeah, so, you know, I've actually spoken about this with some other people for, you know, large-sized companies and so forth, but there is some agreement that we should just move over to that model because the whole question of inventorship has gotten so murky. Like we've just been talking about on here for like the past 15 minutes about inventorship, when, you know, it may not necessarily be the most important question related to a patent. I mean, it does have, you know, some purposes in terms of prior art, identifying whether they had, you know, authored a paper, as we just discussed, for example. But I think that we maybe have to think about the inventorship question a little bit differently as technology improves and how we're viewing it, because it's going to consume more and more resources to identify who is the inventor, so forth, and just, you know, from what we've heard up here, I mean, it's trying to create more and more burdens. But you know, that system, if it, you know, it seems to be working well in other jurisdictions, so I think we should consider it over here as well too, whether we should move into a different model where inventorship isn't necessarily quite as emphasized, and move more so towards the applicant perspective, I suppose. But there is support for it. I think under the radar, there is some support for it.
Yeah, but there is a large school of thought in the U.S. about inventors specifically being recognized, whether it's at the company or by the USPTO, is recognizing and appreciating inventors as an award system to have their names on patents. So
Right.
I feel like that could be just
But
difficult.
isn't it also so that somebody can't take somebody else's invention, right? If you do away with inventorship, I think you need a lot of safeguards to make sure that the applicant is not inappropriately taking somebody else's idea and filing a patent for it, so they're the applicant.
Right, because then I guess in that case there would be no declaration if we have an applicant.
You may also have constitutional issues.
Oh, okay.
Yeah,
It's not a
because,
minor
inventors
revolution.
are entitled to their
It's a
inventions.
constitutional amendment.
You'd also have
Tiny
a
problem.
problem too, because in the AIA, they did away with 102F. There is no 102F. And the patent office, I think, took the position that, well, if it doesn't come up all that often, but if it comes up, we'll deal with it under 101, because a person is entitled to a patent if type language in the preamble 102, but also it's more directly a patent on an invention by an inventor. It comes up under, that concept is under 101. And whether or not that holds water or not, that's what's going on now, right? Because there is no 102F. If we change this, there will need to be a 102F equivalent, because there will be games played. You know, there are already games played. I mean, I don't know, not that this is an AI topic, but how many of you ever on the panel or in the audience, you could just raise your hand or answer to yourself if you don't want to admit it, had somebody call you and say, hey, you know, I was on vacation last week, saw something really cool, don't think they've done anything with it, I want to patent it. You know, and it was always one, and maybe it was just, we got these calls all the time, and it was always somebody on vacation for a friend, I'm asking, type of thing. And it's like, no, you can't patent somebody else's invention. But, you know, we laugh about that, but there's a large group of people out there that want to do that, and I wonder how often that has really happened.
I've had a couple of those calls.
Yeah.
I mean, they happen. I would say on the inventor piece and kind of getting rid of that in the entire system, I don't think that's happening. So that's my crystal ball. But I do think there probably is some opportunity for streamlining procedure and the details of patent prosecution around the concept of an applicant rather than an inventor, right? Like the idea of priority claims or terminal disclaimers, they already revolve around who the applicant is, and a lot of what the AIA did was to bring our system into conformance with those more kind of global concepts. But there's still things that are inventor specific, like by another, right, and those kinds of concepts. So I suppose if there were any change, it might be that you could rewrite certain statutes or certain rules to not be so focused on inventor and be more focused on applicant, but that would have to be a legislative push, I would think.
You got another question?
Yeah, I think that this question about the inventorship is pretty key. I'm pharma. I'm not like anyone else in this room. And it's key there, because there are companies working with other companies or companies working with universities. And it's critical to know who the inventors are for ownership purposes. So it's not, I mean, you can't make a decision based on one technology area, but I will represent that technology area.
Any other questions?
I just wanted to add also the consideration of inventor compensation, regardless of what we do here. There are jurisdictions where inventors, 3M, we have to provide compensation for those inventors based on their contribution in other countries. So I don't see tracking the inventors going away for at least large companies.
Yeah, good to know. Yeah, it just seems like this is it'll be fun to see how this plays out, but hopefully nothing major changes. I feel like the guidance really wants to make clear they want to keep things very much the same based on the language of the guidance. They have many sections repeatedly saying this is not changing, that's not changing, this practice isn't changing.
Nothing's changing, but here's a large 3 pages reminding you of your ethical duties. That always makes me nervous. Nothing's different, but remember.
And also there's also the example section. I was like, oh, this is when you could find. And I'm just like, yeah, that also does kind of make it seem like there is something will be changing, but hopefully nothing changes. I think this is a good time maybe to talk about the 112 guidance that's come out. I mean, it's specifically, it is in view of Amgen, but I thought we'd talk about how it could be interpreted in the AI context, if anything could change for AI, because so much it was involving function so the Amgen case involved function, and function was determined to be a genus. Do you feel that the guidance or Amgen could be problematic for AI cases? I think I'll start with Dina.
So around the time of Amgen is when I started including the machine learning figures into the patent applications. because you just don't know which examiner you're going to get, and you can get an examiner that just says it's not enabling because you say, well, this is a this is like a machine learning network or a deep learning network, and you haven't explained how it works or what's inside it. Right. So to avoid those types of issues, I think it's really helpful to have different machine learning figures that you can include in the application. But at the same time, because there is so many different types of AI, you need to have several, and depending on your conversation with inventors, you can pick and choose which ones you want to include.
And I guess you'd mentioned this before, you have standard figures generically to be used?
So we have standard figures that I prepared, but when I include them, I also tailor them to a specific case.
Okay, yeah, thank you. I think, did we have anyone? No, 112?
People sometimes write claims that say, get this kind of data, do this kind of stuff, apply a machine learning method to do whatever, and then do something useful with it. And then for the enabling disclosure for the machine learning method, you could have one set of figures that very detailed tell you it's a neural network that has this architecture trained this way with this loss function, everything, the works. And then you have this paragraph that says, but in other embodiments, it can be a support vector machine, a Gaussian mixture model. And the moment you do that, in view of Amgen, I think you raise the serious question of whether the breadth of your claim has been enabled. I would argue that it's a dangerous place to go, and I don't know what the value of there's value in defensively publishing that paragraph so that others can't patent it, but it could also go the other way.
Yeah, I think it's foolish for anybody to think Amgen is going to be limited to the biopharma space. It's going to work really, really well to kill a lot of those patents, and then there are going to be people who say, well, hey, it could kill other patents too. And so if you're not paying attention to what happened in Amgen, I think you're going to regret it down the road.
I think that the issue that often comes up, it's when you have inventors who are just using AI. Right, so once you start asking them about the structure of whatever AI, say it's even ChatGPT, right? They don't know what's inside that structure, and that's when you're drafting those types of applications, you're going to have absolutely 112 issues come up.
Yeah.
And also with just the breadth in scope of what some of these AIs are doing, right? I mean, you know what? And this is, I'm going to cascade my thoughts for a minute, but I remember one person who I knew that was doing AI a few years ago would always complain to me. Sometimes she'd call me right after she got off the phone with an examiner just to vent, and it's like, of course it's abstract. It's AI. That's what makes it valuable. It's valuable because it's abstract. It's valuable because I can't tell you exactly what it's going to do. It's valuable because I essentially laid the foundation for it to do something, and then it doesn't, and she would just get very, very frustrated because she would say, the examiners would say it's abstract, and she would say, well, you understand it then. And they would say, no, it's abstract, I don't understand it. Well, no, you can't have it both ways. If it's abstract, that means you get what's going on, right? And it's like who's on first and what's on second. But that very nature of not that you can set up a framework for what's going on, but the framework almost necessarily needs to be very broad, right? And the broader it is, then you wind up, I think, walking into these Amgen questions. And then you wind up, if you go too narrow and specific with the examples, well, it better not be a financial word, right? And now, so I think we're going to have, there's going to be a lot more pain ahead, I think. I don't know. I mean, am I crazy? What do you all think? By pain, I mean litigation pain. Like people saying, "Oh, well, that wasn't enough." That again, the Federal Circuit loves to tell us, "Oh, yeah, we know you did that in response to what we said in that case, but it's still not enough." And it's still not enough. I think we are just starting to scratch the surface on these AI cases, and I think there will be a series of, "Oh, and that wasn't enough in this space too."
Well, the reality is that there hasn't been very much litigation about machine learning and AI compared to other areas, technology areas. But if there's one thing we know, it's that litigators will cause pain. And once it does start getting litigated, they're going to upend everything that we know, because they'll come up with the good lawyers will come up with everything, and then they'll find something to destroy all the work that we've done. Of that I have
and then complain that you got this patent.
But
so they could spend charge $3 million to litigate it.
We seem to be ending very optimistically here.
But what you just talked about treating the AI as a black box, I think now in today's environment is a big mistake.
Yeah.
Like Dina said, putting in the figures that show how the AI works, even if you're just using ChatGPT, put it in there. Put in an example of how this works, and there's lots of stuff. AIs are not just black boxes. Yeah, they are trained to do their parameters. We don't know the details of the parameters and what those mean, but we know that there are layers of nodes that are, they're processing vectors and activation functions, and having loss functions and training things. There's tons of detail that we know. They're literal things that operate in a certain way, and in fact, the way that they're programmed has been kind of reified or thingified as an artificial neural network, as a convolutional neural network. There are lots of words that we have to describe what's going on, and so put those in the patent application. As soon as you treat that as a black box, I think you're just taking on so much unnecessary risk and making your life so hard about treating it like it's abstract.
Well, and I probably, the person who I was talking about, she had a PhD in neurobiology and computational math. So she wasn't exactly putting it, in those terms. But I think I wouldn't say upset, but what caught the examiners by surprise is like when you go from the software, it's if then else, if this then that, if that then this, and you can describe AI in terms of the layers and the nodes and all this other stuff. In my terms, I think what you were talking about earlier, the architecture, right? And what I would just refer to as the framework. You could describe all this framework, but there is a certain power in what it is that we're doing that you're that we are been scared to death about in the first 2 days of this conference about, okay, well, now once we plug it in, what's going to happen? With all those layers in the architecture, what's it going to do on its own? And how is it doing it on its own? And if you tell me the specific use case, then I can go down and I can explain that and do all that sort of thing. But then you wind up with applications in this space that could literally be thousands of pages if you had to go and describe every possible use case that fits with this larger network within the network. And all you'd be doing by giving that level of specificity is proof that you have an Amgen problem, right? Because you're describing this silo and that silo, not the in-between silo. And it's the in-between silo that was missing that was the Amgen problem. And that's the fear that I have. Unless we come to some kind of terms of what does this all mean? How do we describe it? And a certain level of comfort in what in the mechanical and electrical arts would be perceived as abstract and not enough. But for computer people is, oh no, I get it. They didn't explain this here, but I get it. That's if that, then it has to be this. And we lost somewhere along the way this idea that patents are supposed to teach the relevant person of skill in the art, who is not a judge. They're just, none of them are a relevant person of skill in the art. So the fact that you, Your Honor, are confused is not the question.
So Gina, I think as technologies evolve, obviously the issues evolve with them, and areas at the USPTO that didn't have a lot of unpredictability now do, like areas of software and AI.
Yeah.
The USPTO tried years ago to train on the WANS factors the non-life sciences, biotech areas, because they just didn't have to go through the full analysis in past years, but now the issues were evolving to such that they had to. So I look at PTO's guidance as PTO trying to say, look, the laws and standards haven't changed here, to try to get everyone a little more calm, but the issue is also, since the technologies are evolving, even though the laws haven't changed, do new issues now apply? And I think they do. Right? So I think there will be, I'll answer your question that you asked, will there be more, litigation and potential litigation in areas based on AI? I think there will be, but it's just because it's evolving, it's less predictable than it was in the past, and there's a harder analysis about enablement and other 112 issues.
I think you're exactly right, and I think the reason why we haven't seen a lot of the litigation in the AI space right now is because nobody's making any real money in it yet. Because these AIs that are out there don't really work well enough for people to pay for it. Like if ChatGPT, if you had to pay to use ChatGPT right now, it's just not good enough for that purpose, for the average person. Once it starts to get really good, then it's not just people who are inventing and licensing and getting investors with a prospective look of what's down the road and what it could be, and we're going to dominate the world. It's going to be, there's real money being made. I have a patent. I think you're infringing me. Then I'm going to start suing you. And that's when I think the tidal wave is going to crash. Maybe, and I don't think on any of you guys, because you guys, what we've spent here in the last 2+ hours is talking about best practices. And in my experience, if you follow best practices, you always wind up with a good product. I mean, that's just the way it is. And sometimes you can't follow best practices. No offense to the client on the panel. But and it's not Johnson & Johnson isn't to blame for this. But there are some clients that just won't pay you enough to do the best practices. And that's not an us problem as attorneys. That's, I don't even know who it is a problem, but it is a problem. Yeah. But if you have a client that will pay quality people who understand the technology to do a good job, your patents are always going to fare better than somebody who is the lowest bidder.
Mm-hmm. Well, you see, one application that really jumped out in terms of they would have gotten a better result was the American Axle. Because it ended up, causing, people got pretty upset with the result and how that turned out. But then you read the actual patent, it's like, did they pay a patent attorney to do this? What was going on here? How did this even become a
because
thing?
I don't think they even showed an axle, right? It was just all boxes, right?
Well, and for years we say ultramercial and DDR are essentially the same case, right? And they come out exactly opposite. Mm-hmm. The one thing that's different though, and I tell everybody this, is like, if you didn't know which patent was which, and I gave you both patents, I say, okay, one of these patents survived, and one of these patents did not survive. 99 people out of 100 would be able to pick the one that survived and pick the ones that didn't survive. Because if you do it right, there is an innovation there, and if there is an innovation there, you start from day one, ground one, whether it's with the examiner or a district court judge or the federal circuit, they look at it differently. Even the Supreme Court says, oh, no. State Street was an invention. Nothing we're saying here in our 101 lines would disagree with what Judge Rich said in State Street, because that was, or the conclusion, that was an innovation. The test is where they had the problem, not with the hub and spoke system, very complicated hub and spoke system in the State Street case being patentable. But we're at the end here. We should probably give everybody a quick lightning round opportunity to wrap up. This has been a great conversation. Thank you. How about in very rapid fire succession, and you too, Wen, I want you to answer this one. Sure. What do you want people to leave today remembering? Dan.
Oh.
One pithy thing.
My face. No. Draft applications and prosecute them in this area intentionally.
Good, that's really good, and fulfilled the pithy requirement. I love it. Suwan.
Pay your patent attorneys more. No, I'm just kidding. I think
that's good advice.
Well, it does give us more time to work on things. So I say, yeah, emphasize quality over quantity in some cases when you do have something that has value.
Awesome, thanks, Mike.
AI is different, and it should be treated differently when you're drafting a patent. And some of those ways, it's harder, but some of the ways, actually, if you approach an AI application the right way, it's actually easier to get through the patent office. And so treat it like AI. Address directly the architectural and the training and those elements that are unique to AI, and your life will actually be easier.
Yeah, great. Thanks, Mike. Drew?
Tough question because we discussed so much. I like the conversation about the specification. If you walk away from anything that I think is really recognize that that specification is foundational to potential claims down the road, correcting your claims, fixing your claims. So I'd put a lot of care into the specification.
Great, thanks, Drew. Dina?
So I look at recentive analytics, which is a district court case where AI machine learning patents were invalidated in 12b6 motion, and it has and they overcome the one-on-one rejection at the patent office. So it's a great case to read when you're drafting a patent application these days.
Great, thank you, Dina. Rob?
Start with a federal circuit case law that's favorable on eligibility, reverse engineer from there, and explain to your inventor why you're doing it. I mean, it's complicated, but some people would say if getting a patent was easy, it'd be called getting a copyright.
Some people might say that. You know, that's going to be the quote of the conference. Thank you. Brian.
Keep a flexible approach, and just remember, until that cement dries and your last continuation is issued or abandoned, the claims are not as important as your specification. That's kind of the grand threshold. And I'll just leave one more thought. I heard it just about 10 years ago. We're all discussing this now. The one thing I can guarantee you, it's going to look very different 10 years from now.
Yeah, it'll probably look very different next year when we have this conversation. It's amazing. Great. Thank you, Brian. And Wen, your pithy one thing.
Well, I'll take this opportunity to answer a question that was presented to the panel earlier, and we didn't get to it, but what do you do with a prolonged prosecution when you're receiving repeated one-on-one rejections? I would say you start building up a record for appeal, start presenting evidence and arguments for appeal, and because you can't introduce it later on, but it may take another office action rejection, but start proceeding towards that now and then appeal.
Yeah, great advice. I've been saying something very similar for a long time. If you wind up being in one of these art units that has literally a single-digit allowance rate, and there are still examiners that have not issued a patent since Alice was decided, there's no relationship. You have no relationship. I mean, so what you need to do is start building the record and putting evidence in there. And you know, and if an examiner tells you, look, I haven't, sometimes because they will tell you this, I haven't issued a patent in 5 years, or I haven't issued a patent since Alice. Then in your interview summary, say, thank you, we had a great conversation. I understand you have not issued a patent since Alice, and you said that you're not going to start with mine. You know, and get that on the record. And I've had attorneys tell me, well, that would ruin a relationship. It's like, pal, you don't have a relationship with that examiner. But, all right. Thank you very much, everyone.